We have you both here. This is Phillips versus Thompson, our first video oral argument this morning. And each side will have 15 minutes to present their arguments, and the appellant may choose to reserve up to 5 minutes. And I know this has nothing to do with, it's not a criminal case, so there's no victims or anything, but at the same rate, I like to tell everybody we don't use the names of victims and we don't use the names of minors, okay? Because we are recording and it's just better that way. All right, so Ms. McDonald, did you want to reserve any time?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
That's fine. You may proceed.
Thank you. May it please the court, counsel. My name is Laura McDowell. It is my privilege this morning to represent Shirley Thompson and Julie Heiner. The Ohio Supreme Court has stated that a Civil Rule 12F motion to strike should not be used as a substitute for a 12B6 motion to dismiss for failure to state a claim on which relief can be granted. The 12B6 motion is directed to the entire pleading, whereas the 12F motion to strike should be used only to attack individual claims which are not dispositive of the entire action. The 12B or the 12F motion gives the court discretion to strike allegations, but courts have ruled that there are limitations to this power. The motions are disfavored. They're ordinarily not granted unless the language in the pleading at issue has no possible relation to the controversy and is clearly prejudicial. To prevail on a 12F motion, the park in this case was required to prove that every allegation in the counterclaim was completely redundant, immaterial, impertinent, or scandalous, and that the language in the pleading has no relation to the controversy and was clearly prejudicial to the park. In the trial court, the park did not argue and presented no basis at all for the trial court to conclude that the counterclaim presented an insufficient claim or any redundant, immaterial, impertinent, or scandalous matter. And in its decision, the trial court made no such finding. The park—
Counsel, let me interrupt you.
Yes.
I'm a little confused. I want to make sure I understand. So when appellant filed the counterclaim, there had already been a trial in the matter.
No, there was no trial, Your Honor. There was a hearing on the eviction issue, the FED, the forcible entry and detainer.
Okay, but there had already been the evidentiary hearing.
On the FED, yes.
On the eviction. Okay.
Correct.
So, and the magistrate had already issued a recommendation.
Yes, correct.
So when I look at Civil Rule 12, it looks like you should have asked for leave to amend, but I mean, not to amend, but to file the counterclaim. You can't just file a counterclaim anytime you want to, even after a decision's made, can you?
We were still within the answer period, Your Honor. We didn't, in an FED action, the actual hearing on the eviction is held outside the time for filing and answering a counterclaim. It's held immediately within 7 days after service of the process on the tenant. And so the answer and counterclaim in this case were filed within the answer and counterclaim deadline for filing. So there's no rule that I'm aware of that would require us to ask for leave of court to file the answer and counterclaim. And there is a 9th District case law that says we are entitled to file an answer and counterclaim.
Quick question, were the issues addressed in your counterclaim or raised in your counterclaim addressed at the eviction hearing?
A couple of them were, Your Honor, except certainly not as they would be in a counterclaim. So we brought, for example, we have 4 claims in our counterclaim, including violation of the mobile home park statute, and there are numerous violations, of which only one was mentioned at the eviction hearing. Numerous violations. Retaliation, of which only one instance was mentioned at the eviction hearing. I mean, just so the court understands, the eviction hearing being held within 7 days after service on the tenant is a very immediate proceeding, and it's not like you can ask for a continuance so that you can develop your case and present all the evidence that you would present if you were going to go to trial on the case. This is a very brief and abbreviated proceeding that would that requires very little or allows very little time for preparation, and the court's not going to allow you a continuance to get your whole trial ready. That's not what the eviction hearing is for. The eviction hearing is for the simple question of, should this person be allowed to continue to reside in the property or not? That one question.
And you're not contesting the actual eviction order. You're just saying you should have had your day in court on the counterclaim.
Correct, that's all.
But maybe I'm misunderstanding, but wouldn't some of the issues you're raising in a counterclaim preclude them from evicting your client?
It would have, Your Honor, but yes, it would have. However, we did not have that evidence developed, and we weren't able to present it during the hearing on the eviction because, as I said, it was 7 days after, and there are some other reasons as well, which
Well, on your counterclaim, are you seeking damages, or you're not trying to evade eviction on that? You're just seeking damages, correct?
Correct, yes. Yes, she has moved out, and yes, we're seeking damages on the counterclaim.
Okay.
Thank you.
Mm-hmm. And so, as I stated, the park argued only that the very act of filing a counterclaim was wrongful because this case should be limited to the eviction issue. And that's not correct. The Ohio Supreme Court has indicated that counterclaim can be imposed in any action, enforceable and detainer as authorized by Civil Rule 13. And the case that's holds that is cited in my brief. Therefore, according to the Ohio Supreme Court, residents of a mobile home park are authorized to file a counterclaim in an FED action. And the 9th District has also held that in the case of Label versus Flowers. And so the case that was presented at the eviction that was a very hurried presentation made 7 days service is not dispositive of what claims that my clients have against the park. And the use of Civil Rule 12F to dispose of the entire claim is contrary to what that rule is for. And that's according to the Ohio Supreme Court as well. And so therefore the appellant's request respectfully that the court's order be reversed. And
Thank you.
Attorney McDowell, were your clients represented at the eviction hearing, or were they
Yes.
pro se?
No, they were represented.
Okay.
Thank you. Mr. Myers?
Yes, thank you.
Minutes.
Good morning, Your Honors. John Myers. I represent the Eppley Chef LLC. If you look at the underlying action, the eviction proceeding, there were specific findings of fact that were made by the magistrate. There were objections to the magistrate's ruling, and the Judge Hamilton, made specific findings of fact and conclusions of law that relate directly to the counterclaim that was filed by appellants. What is not before the court, and what the appellants have not done, is appeal that magistrate's order. And my client's contention is that those issues have been resolved. Now, some of those same issues are.
Let me just ask a question, because
Sure.
now I'm a little bit confused. When the eviction hearing was held, the counterclaim was not pending, correct?
Correct.
When the objections were made, the counterclaim was not pending. Correct? Okay, so when you said the court made specific findings of fact related to the counterclaim, I think what you mean to say there is those arguments that were made that were incorporated into the later filed counterclaim were addressed by the court. Am I correct on that?
That's correct, Your Honor.
Okay.
I was a little inartful in my explanation.
All right, I just want to make sure I understood the case.
No, but
Go ahead.
if you look at Judge Hamilton's order, which was not appealed, or some of those very factual issues are issues that are also raised in the counterclaim. If you read the transcript of the eviction hearing, it went beyond the issue of non-payment of rent. It went to issues of conduct by the tenants. It also went into issues of the tenants' claims that my clients retaliated against them on account of their engaging in a tenant organization, which is permitted by statute. Those issues were all addressed in that process.
What about the claims involving the mobile home statute, mobile home park statute?
Those weren't addressed, but some of the issues raised in the counterclaim were addressed and resolved. So we're in a situation where there's a counterclaim filed. At the time the counterclaim is filed, well, ultimately the court rules against the tenants on many of the issues raised in the counterclaim. For instance, the retaliation claim that was raised at the hearing. Now, the tenants could very well have appealed the trial court's order affirming the magistrate's decision, and they did not. So, Your Honor, even if some of the allegations in the, assuming for argument's sake, some of the allegations in the counterclaim are valid, many of those issues have already been resolved by the court. It's an odd situation. From my standpoint, the only issue that was appealed was the motion to strike the counterclaim.
Let me just interrupt you again, Mr. Max. So the way I understand the procedure was the hearing was had, and then the magistrate's opinion was written, and then the counterclaim was filed before the judge had signed off on it, or had the judge signed off immediately on it?
No, the judge signed off. Actually, the counterclaim was filed before the judge ruled on the objections.
Okay, but there already was a recommendation before.
Correct. There was,
Okay.
All right. The hearing officer made recommendations, and those went beyond just the non-payment of rent. Don't get me wrong, there were substantial questions about the non-payment of rent, and from my experience in eviction proceedings, generally it's just the issue of non-payment of rent. Period. If you paid, you can stay in. If you didn't pay, you're going to be evicted. Those other issues are reserved. But this case is at least unique in my practice in that the issues went beyond just the failure to pay. Mm-hmm. And Judge Teodosio, I think if you look at the retaliation claim, at least one of the mobile home park statute permits the tenants to organize. The issue of that issue was addressed as to the tenants because there was testimony that they claimed that they were retaliated against because of activity they took complaining about issues in the park. So while Judge Hamilton didn't address that directly in his opinion, that issue was raised and litigated at the eviction hearing. So the problem here is they're looking for another bite at the apple on many, if not all of these issues.
What about the court's analysis? Wouldn't 12B6 be the more appropriate rule to apply in this situation?
I wasn't involved at that stage. Arguably, yes. But at the same time, it still doesn't, whether it was a 12 after 12B6, the fact of the matter is there were underlying issues raised in the counterclaim that were already litigated and resolved by the court. So therein lies the issue and controversy here.
I guess I've got so many things running through my head right now.
It took me a long time to figure this one out in my head.
But I guess one of the things I'm wondering is the arguments you are making sound, more in the realm of issue preclusion, res judicata, because the court's already ruled on it, not necessarily to prevent you from filing for them filing a counterclaim. That in answer to that, you could raise the issues of res judicata or even a motion, for summary judgment on those. Those are already, so it gets a little confusing here. So I'm wondering what your response to that is.
I can see your point on that, Your Honor.
The problem is, it's like Ms. McDowell said, this is such an expedited procedure.
But you can still ask for time in the eviction process. You just can't. Granted, if she would have filed the counterclaim immediately prior to the eviction hearing, the court wouldn't have addressed those issues, would have set those issues for another date. Because if you read through the transcript and you look at the ruling, the true issue that needed to be resolved in that expedited process was rent paid or wasn't it? Period.
But my understanding was, and I have not read the transcript yet, which obviously I will do, but but my understanding is that the appellant was actually paying the money in escrow.
No.
Okay.
No.
Okay.
She was behind, just Judge Carr. She there were some issues in the September timeframe. It must have been 2022. She, instead of paying it into escrow, she held September, October, and tried to tender all 3 months payments in November.
Okay.
And the park, within their legal rights, refused.
Okay. Thank you for clearing that up.
You're welcome, Your Honor. The long and short of this is, from a civil procedure standpoint, this is it's a mixed up case. And Judge Carr, I can appreciate your issue, that your question regarding is this a better argument, a res judicata argument, or to be raised in the motion for summary judgment? Yes and no. The fact of the matter is, the tenants knew these issues were resolved. They tried to proceed with a counterclaim.
It's been a while since I looked at the court's order. Did the court make the findings necessary for 12F, or was it required to make the findings of immateriality, scandalous, redundant, those elements of a 12F?
No, the court simply concluded that this court, having reviewed both motions, finds that plaintiff's motion to strike is well taken and finds the plaintiff's motion to strike defendant's counterclaim is granted. So there were no specific findings at the trial court. again, it doesn't give us, there's a lot of meat on the bones for that. If the court has no further questions, I will rest my argument.
Thank you. And Ms. McDowell, you have your full 5 minutes.
Thank you, Your Honor. The counterclaim includes a number of allegations that were not addressed in the eviction hearing. And the suggestion that a tenant's time within which to file a counterclaim, an answer and counterclaim, should be reduced to less than 7 days after service of a notice of eviction. If that is the case, that should be incorporated into a statute or rule, because that is not the current rule. The current rule is, as with any other civil action, that a tenant has 28 days after service to file an answer and counterclaim, and that is what was done here.
Well, let me just ask you a couple questions in regard to that, because you know, I used to be a municipal judge many eons ago, and I remember signing all the evictions, and then if there were issues for damages or another cause of action, we'd set them over for separate hearing. And but I'm trying to think about this, because this is a very unusual case. There's no doubt about it. But what I'm wondering is, I understand your point that you have 28 days. However, evictions are by statute. Evictions are a completely different kind of action. And I'm wondering if the trial judge, and I don't know how they do things now over there, but if the trial judge had signed off on the magistrate's decision at the same time, obviously subject to objections, I'm wondering when Miss McDowell does, you know, that could be before your answer time is over, I guess is what I'm trying to say. At some point, you can't just come in after everything's been ruled on and say, okay, now I want to file a counterclaim.
Well,
I mean, it's weird, I know, but.
I mean, I respectfully disagree, Your Honor. I think that's what the statute and rules permit. And there are issues with in a tenant-landlord relationship that go beyond just eviction. And that was addressed in the label case in the 9th District. In that case, the 9th District ruled that the tenant who was alleging racial discrimination was entitled to bring that, or that bringing of that counterclaim was not frivolous, even after the eviction was granted. And so that is, I mean, because the eviction process is so abbreviated and prompt, and, you know, Mr. Meyer said you can ask for a continuance. Good luck trying that. I mean, the courts are very strict with trying to make sure that the landlord gets their property back very promptly. And so, you know, if you go in and say, you know what, I'd like to make a counterclaim here and bring in all these things and take discovery and make a full presentation of the issues before the eviction. I mean, as a municipal judge, maybe you can recall, would that have been something you'd have granted? Push that down the road 6 months? I mean, it's
Well,
not.
Let me ask you this then. Was this a compulsory counterclaim?
Yes. I mean,
You don't think you could have filed a separate action?
I believe this is compulsory, and the 9th District in Label said that it very well may be compulsory. So, I mean, I think the issue whether a counterclaim in an eviction claim is compulsory, I don't know that that has been conclusively determined, but the 9th District has said that it very well may be, and I certainly wasn't going to be the one who got decided that, yes, it is, and you messed it up. So,
I understand that.
okay.
And you have just about 1 minute left.
Okay. I would like to address very quickly the issue. The magistrate made findings of fact. We filed objections, and Judge Hamilton then made a ruling, and he adopted the findings or adopted the decision of the magistrate. In his ruling, he also added some statements about what the evidence showed and things of that nature. That's dicta because he specifically adopted the magistrate's ruling. And so the finding or the allegation that there's something beyond what the magistrate ruled and that's the law of the case or some sort of finding in the case, that's incorrect because the judge did not modify. The judge could have modified the magistrate's ruling, but he did not. He chose to adopt it. And so what's on the record is the magistrate's findings and conclusions. And so that is in the record. You know, I would also like to say that our failure to appeal the eviction was not a mistake. We did that on purpose. And that's because I don't choose to waste your time. You know, by looking at the evidence, you know, my client was very sick that day of the hearing and she was unable, I mean, it was later determined what her problem was. She didn't know and I didn't know on the day of the hearing, but she had a really bad day. And the way that evidence came in, you know, I looked at it and made a determination, and that's, you know, why that issue didn't get appealed. But
and you're saying when the magistrate issued its recommendation, its order, the magistrate, it was only a finding of eviction, that they hadn't paid rent and that eviction should be granted.
The magistrate said that the defendants failed to pay rent, that they got a 30-day notice, that they violated the lease agreement and park rules, and that they didn't tender rent.
Thank you.
That's exactly what the magistrate said.
Thank you.
So there's no further, you know, findings or anything that would specifically address the allegations in the counterclaim. Nothing.
Thank you. And unfortunately, you're out of time.
Okay,
So,
thank you.
Thank you. We will take the matter under advisement and issue a written opinion that will be sent to the parties, as well as we release on the Supreme Court website, so you can get it earlier if you want to go online. So thank you both for your presentations. Very interesting case. We appreciate it. Thank you.
Thank you, Your Honor. Have a good day.